This is all about employment generations, employment promotions, and also overseas employment. We will be discussing likewise articles relating to overseas employment, including generations both locally and abroad. And finally, cases relating to overseas employment, especially those arising out of or by employer-employee relationship involving overseas Filipino contract workers, or if there is no contract at all by virtue of any law that regulates the relationship with respect to employment relations. We know for a fact that employment can, should I say, be forged even without a written agreement. By the shaking of hands would mean that there's already employment relationship. There is already employer-employee relationship. So we will start with discussions on employment promotion generation. We will discuss laws governing generation of employment. We will first discuss with Republic Act 11261, or the First Time Job Seekers Assistance Act, which was promulgated sometime in 2019. This is a new law. And this is also in relation to, as you can see or follow your syllabus, Department Order number 204 to 204-A, series of 2010. Now, the Job Seekers Act gives a privilege to those first-time job seeker, the right to be free from charges on their applications relative to NBI clearances, access of public records, ano pa ba yun? Yung mga medical certification from the public hospitals, police clearances, barangay clearances, and everything. Anything in regard to the application for employment with public or private sectors. However, when it comes to the obtaining of these clearances, especially medical clearances, you have to go to the hospital. Admit ko muna. And the public or government hospital, because if you obtain this from private hospitals, you have to pay at least fair and reasonable fees. So to be free, you need to go to the hospitals, public or government hospitals, or public or government clinics, in order to obtain these clearances for free. Now, what is the necessary and dispensable requirement that you need in order for you to obtain these clearances for free? You need a barangay certification to the effect that you were just a first-time job seeker. If none, you're disqualified. Okay? It is also necessary for local government units to register the list of first-time job seekers in their respective territorial jurisdiction. If you are not included in the registration, then you are disqualified from getting these certifications or clearances, including the application of UMID, application of Pag-ibig, SSS, okay, including tax identification number. It's for the first time. All the expenses that you may incur there except of course the transportation going to the public office, are all free. Okay? Questions?
And so far, sir.
Ayan. Si Nico. When it comes to the roosters of first-time job seekers, the local government unit concerned, especially the municipalities or cities, be it component or highly urbanized cities, all these roosters of eligible first-time job seekers must be furnished to the Department of Communication or ano ba yung DICT, Department of Information and Communication Technology. Okay? The DICT has regional offices. So the regional office to the regional director must accumulate all this roster of eligible job seekers from their respective territorial jurisdiction. Okay? Take note of, although wala dito sa natin sa employment generation syllabus, there is a Department Advisory number 7 series of 2020 in relation to Department Order 204 to 204-A series of 2019. This relates yung Department Order na 7. Should I say, first-time job seekers, okay, must be certified by the respective barangay unit. It is there should be an obligation on the barangay or the local government unit to register. This is in accordance with the DOL advisory, obliging them to register the respective first-time job seekers in the respective territorial jurisdiction. In addition to that, the Secretary of Labor and Employment obliged them, especially the employers, the private sector employers, to obtain only a photocopy of the clearances. Okay? Only for purposes of application. But when it comes to the provision of job offer already, when you were already employed in a company, then the management prerogative will apply. How is this? By exercise of management prerogative, the employer can require authentication of whatever you submitted to them, di ba? Siyempre, empleyado na kayo eh. So, since you're employed in that company already, you have to give them or provide them at least a certified true copy or any authenticated document. Kasi part na kayo ng company. And that is in the exercise of the respective management prerogative in accordance with the promulgation of rules, policies, and guidelines pertaining to employment. Okay? So the DOL advisory will only be limited to the application. Siyempre, parang nag-apply pa lang tapos i-require mo na ng authenticated. Paano kung hindi matanggap? How can he apply again to another private sector employer kung hindi nyo ibalik yung certified true copy niya or yung original or authenticated copy? it's very hard to obtain authenticated copy of these documents. Okay, questions?
None so far, sir.
Okay, let's go to Department Order number 204. Ano lang dito, maliwanag eh, kaya I cannot see even myself. Anyway, it's okay. Well, as long as the voice is clear. Don't mind my appearance here. Okay. Department Order number 204 relates to employment generation. In this case, the qualified job seekers here, this is still relating to employment promotion and generation, is from 18 to 30, 35 siguro, youth eh. 35 years old, o 18 to 30 years old. Okay? This, syllabus ito. Department Order 204 to 204-A 2019, promulgated on July 29, 2019. So, this is relating to the Department of Labor and Employment government internship program. How is that internship program? When you would like to enter the government service. However, when you enter government service under internship, it does not necessarily follow that you're employee of a government instrumentality. Okay? You don't have yet employer-employee relationship. In fact, in government, even if you're already beyond the internship age, okay, the government has the absolute or wide latitude of discretion, or sometimes we call it wild, hindi wide lang, wild latitude of discretion, either to make you permanent or to stay you temporary forever until you retire. The period of internship is minimum of 3 months to 6 months. Diba? Ano naman yung normally training ng government internship? Bibili ng banana queue, kamote queue, and then well, that's part, diba? Well, just to share you, when I was with the Office of the City Prosecutor, kasi I was the youngest prosecutor in Manila at the age of 31 yata during that time. Eh mga kasama ko nasa 50s na pataas. Siyempre initiation ng bagong piskal. During that time, pinabibili ako ng banana queue, kamote queue, mga ganyan. Lugaw. For 1 year. After 1 year, they accepted me as part of them. Maganda rin. Sabi niyo, how can you... during that time, by the way, just to share my experience, I have only short of 5-year experience as a lawyer. Ang fiscal kasi, you need at least 5 years experience in the practice of law. During that time, 1 taon lang ako. How come, sir, that you got the position? Well, it's so fortunate for me that my share lang to, baka huwag nyo i-quote na lang. One of yung niece ni Secretary Gonzales, the Department of Justice, used to be my mutually understood friend, parang gano'n. In Department Order number 204 ano ba yun? Ayun na yung mata ko yun. Feeling pa kasi. 204-A, diba? Nakalagay dito, all industries are qualified, diba? And only 18 to 30 years old. And those who have not yet undergone internship program with the government. But because of 204-A, the internship was extended under 204-A to those job seekers who are affected by natural calamities or disasters. Although they were already employed in the private sector by the employer, but because they were terminated or laid off because of natural calamity or disaster, because of involuntary closure. When you say involuntary closure, we're referring to closure of business or cessation of business or operation due to what? Bankruptcy, di ba? Okay, due to insolvency on the part of the employer. Siyempre, kailangan you have to prove it first. Yung bankruptcy, insolvency, okay? Or you have undergone, the employer have undergone financial rehabilitation. In the meantime, the employee's number must be reduced. So if you're affected by the reduction of the number of employees, then you can still be qualified under this program. Okay? If you're indigent, siyempre kailangan mo ng certification of indigency. Sino mag-i-issue? Siyempre, barangay na naman. Okay? Anyway, malapit na yung ating barangay election. Okay? So, please elect those worthy barangay chairman and sangguniang barangay members. Okay? Even yung kasama yata, di ba, yung barangay sangguniang kabataan. Okay, I used to be with the sangguniang kabataan also. Pero hindi na SK noon eh. Dati kabataan barangay KB. And then luckily I became SK Federation President. So naging technically municipal councilor ako for 3 years. 3 years only. But after that, when my term had lapsed, I re-elected. Pero unfortunately, I lost the election during my re-election bid. Kaya ang ginawa ko, sabi ko, kung hindi ako pwedeng maging konsehal, di council na lang, di ba? Pareho pa rin naman ang pronunciation. Yung council sa council. Council is becoming a lawyer. So, fortunately, I become a lawyer right now. Articles 12 and 14 of the Labor Code of the Philippines as amended. Okay. These are just fashion statements in relation to Article 2. When I discussed you, di ba yung Article 2, remember? Of the 1987 Constitution, the Declaration of Principles in State Policies. If you still remember. Okay. We reiterate the fact that it is the policy of the state to maintain a state of full employment. Although, in truth, in reality, hindi naman full employment tayo. Diba? And since we advocate full employment, in a way, we improve the manpower, training, and allocation of workers to various parts of industries. Diba? So how do you allocate them well? Through the local government units. Diba? Making them cities, component cities, or advanced or highly industrialized cities. Hindi lang Manila. Kasi in order for them to be encouraged to go back to their respective provinces kaysa ano tayo dito? Dumami tayo sa Manila, di ba? You can also excel in your respective provinces by being employed in various industries. Kaya our local government unit used to come up with their respective laws, bills of local application to improve the cost of living in their respective territorial jurisdictions. Okay? Another provisions, especially in Article 12 of the Labor Code, is the protection of our local or citizens as against alien. Okay? So how do you protect our local citizens? Diba? Siyempre, prioritize employment to our local citizens. And by prioritizing employment to our local citizens, you must regulate the employment of aliens within the Philippines. Tama po ba? So, how do you regulate employment of aliens in the Philippines? So, make employment of aliens in the Philippines as a privilege, not as a matter of right. Compared to our employees who are Filipino citizen or resident alien. Kasi we're talking only about non-resident alien here in the Philippines. Kasi pag resident alien ka na, means that you are married to a Filipino or Filipina, you got naturalization, you're already a resident alien within the Philippines. So, your right is the same or substantially the same as the right of a Filipino citizen. So, ang protection lang natin is laban sa mga non-resident alien who would like to be employed within the Philippines. You cannot be employed here in the Philippines without first obtaining an employment permit. Okay? Another, our local employees within the Philippines would like to be employed abroad. Okay. So you need also to protect them from abuses. You need also to highlight the privileges afforded to them by the recipient country. How? Siyempre, by coming up with a treaty or an international agreement. Like, marami tayo sa Hong Kong, di ba? Although, DH lang, pero okay na rin. At least, nababawasan yung employment natin, ay yung ano natin, unemployment problem in the Philippines. Although, even European countries, di ba, we ended up domestic helper or household chore employees. Okay lang. Okay? But sabi natin sa Amerika, maraming immigrant doon. As early as 1970s up to the present. Kasi bakit ko nasabing 1970s? Kasi 1970 ito yung number 2 pa tayo sa Asia, Southeast Asia, o Asia. In general, Asia, tama. We're second to Japan. Pero 1971 onwards, wala na. Ngayon, number 2 pa rin tayo. Di ba, tama? Kaya lang, nasa bottom 2. Okay? Hindi na tayo top 2. Bottom 2 na tayo. Accomplishment pa rin yun kasi bottom 2. Di ba? Okay. Another is the strengthening of peso. Alam niyo ba yung peso? Public Employment Service Office. in every locality meron na tayong institutionalized na peso. Okay, in collaboration with local government units. This peso, what is this all about peso? In fact, meron tayong peso law where they should be instituted in every locality, especially component cities, okay, first-class municipalities, and highly urbanized cities to have peso in their respective territorial jurisdiction. The peso is the one that link between the private sector employers with the job seekers. Okay? The facilitator of employment is the peso. Parang ano to, if you're familiar still with yung JobLink, PhilJobNet, mga ganon. Sa government naman, yung brightest for the bureaucracy program in the government wherein mag-exam ka lang ng civil service first level or second level eligibility, di ba? And then, if you get at least 85%, you will be subjected to another examination again ng civil service. At pag pumasa ka na dito, okay, you are guaranteed employment. Okay? May ganon. You Google it, meron ganon. Meaning, ang gobyerno na ang maghahanap sa'yo, hindi ikaw yung maghahanap ng trabaho. So, fortunate, sabi niyo, mayabang naman tong hayop na to. Ano lang, nagkataon lang na pumasa din ako dito, kaya during my time, when I took my civil service eligibility, pinalad naman, umabot ng 88 yung ano ko, nag-exam ulit ako. So, I was guaranteed employment. Kaya lang, yung ginaranti na employment sa akin, parang ayaw ko. Kasi, gusto ko sana noon, sa Department of Foreign Affairs, parang gano'n. Eh sila pala, hindi, dito ka na lang, civil service, napunta ako ng civil service. Hindi ko naman gusto doon. Nung gagawin ko doon, conduct ng exam. Gano'n. Pero, at least, di ba, sabi naman nila, guaranteed ka naman. Kami naghanap sa'yo ng employment. Pangit naman. Anyway. Because of that, I was, siguro, nagpursige ako na mag-continue with my education to become a lawyer. Hindi taga-conduct lang ng exam. Ako na yung nag-exam ngayon sa court. Cross-examination, di ba? Or direct. Okay. Ano pa ba? Okay. Because of the policy to ensure protection, programs and activities of the government, we come up with dividing the departments to cater the overseas employees and the local employees, di ba? Kaya hindi na ngayon sakop ng DOLE lahat ang employment. So we make it specialized. We have already the Department of Migrant Workers, so DMW, parang BMW. Yun ang dream kong car, BMW. Although may expedition na ako. Okay. So, Department of Migrant Workers. This is now headed by no less than Susan Toots Ople. Diba? Anak yata? Tama, anak. Anak to ni, dating Labor Secretary o Labor Minister of Labor, Blas Ople. Si Susan. Although nag-run ng senator, talo. Pero dahil nakadikit kay BBM, na-appoint, di ba? This is former, if you still remember, former Philippine Overseas Employment Administration, di ba? So, all the functions, responsibilities, duties of the POEA is now assumed by the Department of Migrant Workers. Okay? The law that applies here is not already the Labor Code of the Philippines, but the Migrant Workers Act, di ba? Of 1995, Republic Act number 8042 as amended by Republic Act 10022. Mamaya di-discuss natin yan. Okay? Department of Labor is now in charge with local employment or local employees. So, medyo specialized na. The OWA, the Philippine Overseas Labor Office, POLO, is now under the jurisdiction of the Department of Migrant Workers. Okay? Yung BLE, yung Bureau of Young Women and Children, Bureau of Labor Statistics, Bureau of Rural Workers, are still under the Department of Labor and Employment. Okay? Okay. Ay, naiwan pa ba? So, 60. You have questions? In the promotion or generation of employment, the Department of Labor is also maintaining a labor force participation rate. Ano to? Ito yung mga list of employees who are in active employment and employees who are actively participating but have no employment at all. Muna. Or labor employees who have been actively participating but ceased to be employed in the meantime because of some labor disputes. So, meron dapat tayong list of these roosters. So, ang nagmi-maintain yan is Bureau of Labor Statistics. Okay? When it comes naman sa yung employment, underemployment, informal sector workers versus formal sector workers, ang ano naman dyan, ang nag-maintain ng list are the National Statistics and Coordination Board, Alien Employment Permit. So, meaning, kasi ang Alien Employment Permit kasi, for your information, is 2 to 3 years ang kanyang lifespan. Okay? And before it will expire, lalo na nung pandemic, you need to renew it. If not renewed, yung list of aliens nyo employed in accordance with the Alien Employment Permit are automatically be terminated. Their contract, even if it's not yet expired, but their permit is already expired, automatic yung kanilang termination. They become illegal here in the Philippines. They have to be deported if their alien employment permit had already expired. Okay? So, kaya naglabas ng labor advisory. Employment of alien within the Philippines. How is it done? The employment permit is required only to resident, as I've said a while ago. The employment permit is required only to alien, non-resident alien in the Philippines who stay not more than the aggregate period of 180 days. Yung mga tourist, kunwari sa Pilipinas, tapos they want to stay here for work. So, they need to apply alien employment permit. Okay? Yung parang sa abroad din, nag-TNT tapos kailangan para magstay ka for longer period there, you need a working visa. In the same manner that in the Philippines, those alien, non-resident alien in the Philippines would like to stay longer than the 180 days. Okay, yun ang maximum kasi pag non-resident alien ka sa Pilipinas. Your maximum stay here is only 180 days. Okay? Beyond that, you are considered illegal. Diba? Okay. Alien employment permit is only available to aliens in the Philippines who would like to be employed, provided that the employer who decide them to work with them must prove the fact that there is no Filipino who is qualified, able, and willing to do the job for which the alien is desired. Okay? So if the employer who would like to employ an alien, non-resident alien in the Philippines, can prove the fact that there is no employee or local or Filipino citizen who is qualified, able, and willing to do the job for which the alien is desired, then employment of alien is allowed within the Philippines. Okay? Another is the employer must execute or prepare and execute an undertaking. Okay? To prove the fact that the alien, besides from being qualified, must train a Filipino or local for 2 years. There should be an undertaking on the part of the employer requiring the alien to train locals or Filipinos here in the Philippines. Okay? So, what is the purpose why you have to train locals? So that sooner or later, after the period of 2 years, these local citizens in the Philippines can now replace the alien. Kasi we still give priority to our citizens here. Ano ang example dito? Well, there is also a case here. Hindi ko na nilagay dito pero we have a case in the Philippines. If you still remember the case of Norman Black, Tim Cone. Siguro ano na kayo, hindi kayo mahilig sa basketball. Siguro volleyball o badminton o ano man. Tim Cone is coach siya sa Alaska dati. Okay? Kaya during that time nanonood ako ng basketball Alaska kasi back-to-back champions sila eh. Because si Tim Cone magaling kasi mag-coach. Eh siyempre maraming inggit na coach sa Pilipinas nag-file ng case sa korte and it reached the Supreme Court. Sabi nila meron tayong Philippine Coaches Association of the Association here. So bakit hindi dito kumuha ng coach? marami naman qualified. Bakit si Tim Cone na alien? During that time, Tim Cone is a non-resident alien here in the Philippines. Okay? Later, okay, General Milling Corporation to case. Later, the Supreme Court decide that Tim Cone is disqualified from becoming coach again of Alaska because he is a non-resident alien. There are so many Filipino citizens here who are qualified, willing, and able to do the job for which Tim Cone is desired by Alaska. However, ito yung however si Tim Cone nakapag-asawa ng Pilipina. Eh di, multi-academic yung kaso. Pa-champion pa rin ng Alaska. Ibig sabihin, na-continue pa rin despite the decision of the Supreme Court because Tim Cone became now what? A resident alien kasi he married to a Filipina. Di wala na, walang kwenta yung decision ng Supreme Court. Okay? That's what happened. Okay. Next tayo. There should also be a roster of eligible aliens within the Philippines, which should be maintained by Department of Labor and Employment. Okay? I don't know if considering that there's already a Department of Migrant Workers, wala pa naman polisiya that the roster of eligible aliens within the Philippines with an employment permit is still with the Department of Labor. So, baka nasa dole pa rin ang pag-i-issue ng employment permit. We don't still have the policy that it was already transferred to Department of Migrant Workers. Wala pa naman. Wala pa. Okay? What about expats? Ano naman itong mga to? Expats. Can you employ expat within the Philippines even without the employment permit? Well, they are specialized employment. So, since they are specialist employment, it is not the DOLE that give them the permit. It is the Department of Justice. Okay, sa mga expats. How about consultants? Well, consultants, kaya marami tayong circumvention ng batas eh. Kaya magtataka kayo, maraming alien dito. And they stayed longer than 180 days. Because they can be either consultant, investor, expat. Okay. So, same true with investor. Meron din mga investor sa Pilipinas. In order to protect your investment. Siyempre, you stay here in the Philippines. So, meron kang tinatawag na investors visa. Diba? So, investors, sabihin nyo, sir, lalo na sa mga companies na 70-30, 60-40 na corporation wherein the aliens are allowed to buy shares of stocks. So, they should stay within the Philippines, especially when you're elected as board of directors of the corporation, di ba? Sa mga call center, offshore banking units, multinational corporations where you're an expert, or you're a consultant, expat, or investor, stockholder, director, you should stay here in the Philippines to protect your investment, to protect your money. Diba? So, hindi yan covered ng employment permit. Okay? However, you cannot manage, even if you're being granted employment permit, you cannot manage a Filipino corporation. Let's go to the articles. If you don't have any questions. Yung articles, ito yung mga kay Imperial. Bago tayo pumunta dun sa migrant workers, let's discuss first the articles. Yung kay Imperial, King, Kabato, yung tatlong articles na yan. Okay? Okay. Okay, so let's go to the articles of Imperial. Imperial is all about overseas employment, a growth strategy. Okay? Well, our employment in the Philippines, okay, grew because of the institution of various laws. As early as 1898 ba yun? Alam niyo yung statute ni yun dyan, yung Isabelo de los Reyes. Are you in UP right now? Nasa UP kayo?
Yes, sir.
Okay. So, when you enter UP Soler, you see statue there of Isabelo de los Reyes.
Yes.
Okay. Kaya tayo may Soler because of him. He organized the Obra Democratica Filipina, the first labor organization in the Philippines. So, as early as that time, there was already policies on labor. Kasi during the Spanish time, alam niyo naman, during Spanish time, kaya tayo po may cedula, tayo mga Indio, Pilipino. Okay? Because that cedula is your pass that you are a migrante, or meaning migrant in the Philippines and working either with the friars or with an hacienda. Okay? Pag wala kang cedula, ibig sabihin, hindi ka citizen of the Philippines during Spanish time. Okay? Either trabahador ka ng hacienda or trabahador ka ng mga praile. Okay? Kaya tayo mga Pilipino, we are slave in our own country. Okay? Kaya yun, sanay tayo maging slave. Hanggang ngayon, slave pa rin ng Amerikano at ng iba pang mga foreign countries. Amerikano in the sense that we're still under American regime. Our own policies. Yung ating di ba? Yung ating correspondence, yung ating communication. Kaya ako magaling mag-English kahit galing ng probinsya. Kasi, because of the Americanization of our textbooks. Di ba? During the time of Commonwealth regime. Di ba? Our first teacher during that time are Thomasians. Economic benefits, social and economic benefits, and social and economic or psychological cost. Okay? Ano naman to? In a nutshell, when you deploy workers for employment abroad, we ease out our unemployment problem. Di ba? Tama naman. We solve, in a way, temporarily, our unemployment problem. Although we increase, in reality, underemployment problem. Bakit? Siyempre, yung mga kunwari, nurse na dinideploy natin abroad. Bakit? Nurse ba sila doon? Hindi naman eh. Ano ba sila? Caregiver. Yan. Yung mga teacher natin na dinideploy sa abroad. Di naman sila teaching doon, no? DH. Okay? Or any other 4-year courses. Yung mga professional natin na doctors, they have to enroll in a special education program abroad para maging nurse. Imagine, doktor na, naging nurse pa. Kasi mas madali daw ang employment abroad if you're a doctor and then you will end up nurse. So, underemployment, correct? Mga engineers natin, engineer na, civil engineer dito sa atin. They ended up master's craftsman, master's electrician, master, kahit anong master na, bahala na kayo. Okay? Ibig sabihin, they are not full-fledged civil engineer abroad, but they are only master's electrician, that is short of degree. Okay? Yung mga parang technician, if you're familiar. Yung mga aeronautical engineer natin na dapat piloto sa abroad, hindi. Technician sila. Airline technician. Ganyan. Kung alam lang natin, di ba, dapat nag-test na lang tayo. Huwag na tayo nag-aral ng 4-year course. Yun din lang naman pala sa atin pag pupunta tayo doon. Anyway, these are the economic benefits. We pump prime our economy because of the generation of employment abroad. In fact, our overseas migrant workers contributed to the economy through remittances. Okay? In fact, on a yearly basis, meron tayong parang 3.5 billion remittances na galing sa ating migrant workers. Okay? Siyempre, pag may remittances, may galaw, may activity, di ba? So, in every remittances, merong corresponding taxes. So, yun yung na-generate natin. Okay? How about in their personality, in their person as a migrant worker? They gain the status or recognition in the community. Di ba? Siyempre, pag may pera ka na, sa pag-uwi mo dito, okay? O, uy, mayaman na si Juan de la Cruz, si Juana de la Cruz, di ba? Patayo ka naman ng bahay na hindi mo na kayang akyatin. Okay? So, what will be the result? Siyempre, liability yan kasi malaking bahay. Wala namang income. Okay? Although, you can generate taxes because of construction, materials. Pero, temporary lang yon for a limited period. After ng construction, liability na yan. Okay? Kasi wala namang na-generate na income. In this case, bakit? Kasi there is no post-employment training or seminar given to the migrant workers. After the employment abroad, pagbalik dito, since wala silang alam sa business, they will end up going abroad again to, ba? Para mag-ipon ulit, di ba? Parang yung mga seafarers natin, pagbalik dito, lose tayo ang pera, mga babae, mga lalaki, okay, magpunta sa club, etc. Pag ubos na, okay, sakay ulit ng barko. So, it's a cycle. So, dapat meron tayong post-employment employment program ng Ngayon kasi hindi na DOLE, di ba? Department of Migrant Workers. Meron tayong dapat gano'n. Okay? For them to be self-reliant individual. Okay, yun yung benefit. You gain recognition, you gain status in life when you go back here in the Philippines. However, there is also cost. Merong ding disadvantage. Kasi, you can come up with a dysfunctional family relation. Bakit? Siyempre, pag wala yung isa sa haligi o isa sa suporta ng tahanan, either the husband or the wife, napapariwara yung anak, di ba? So, merong psychological o social effect. Dahil yung disiplina hindi na inculcate na maigi because only one is present in the family, either the husband or the wife, yung anak, napapariwara. Tapos, dahil maraming pera, di nakakapag-gig yung anak kung saan napunta. Hanggang sa, either nalulun na sa droga, madami ng experience, masama, baka magka-AIDS pa or ano pa, di ba? Another is yung psychological. Okay? What is emotional? Kasi dahil wala si husband o wala si wife, okay, mabait naman si kumare o si kumpare, yun na yun. Sometimes you will end up to be dozen in the family. One from the legal wife o legal husband, one from kumare o kumpare, one from ninong o ninang, o kung sino pa. Okay? Siguro, have you seen already the movie Anak? Ni Claudine Barreto? Yan, ganun yung cost where you can have a dysfunctional family. Kasi wala yung isa. Ano pa? Maybe abuses. Anong abuse? Sexual. The husband sa anak. Parang sabi, wala naman si mama mo, hindi ikaw na lang. Parang gano'n. May mga gano'n, ha? And then also, division in the family. Family of the wife and family of the husband. Okay? Tapos mawawalan yung anak. Imbis na mamahanahin ng anak, hindi, mapupunta sa kapatid ni wife o kapatid ni husband. Ano? Conflict. There creates a conflict. And also neglect. Neglect. Siyempre, mapapabayaan mo yung anak mo, di mapapariwara. Okay? And finally, infidelity. Ayun, katulad kanina sabi ko, di ba? Sometimes, ba? Mas better na lover pa si kumare o si kumpare kaysa si husband o si wife, di ba? Okay. So, these are the economic or social and economic benefiting costs according to Amelita King. Last, si Cabato naman. A note on Philippine policy on managing migration in the Philippines. Sabi ko kanina, as early as 1970s, di ba? Filipino migrate abroad. Sabi nga ng study, parang almost 10% ng country's population. Okay? Were scattered in almost 200 countries or territories around the world. Okay? They work there as an immigrant, as a resident citizen, a resident alien. They work there as a dual citizen, or even an illegal alien. Wala tayong choice kasi wala namang trabaho dito. So, sige na, mag-tourist tayo doon sa somewhere else and then TNT hanggang magtrabaho temporarily. At least meron tayo dito kaysa dito sa Pilipinas. Okay? In fact, sa Amerika, ilan na ba? Parang mga 1.8 million na. So if you, pag dinugal mo, ang migrant na Filipino migrant, okay, sa Amerika is around 1.8 million na as of today, as of this year. Tayo na yung fourth largest alien migrants in the United States. Fourth largest na tayo because of that. Sa Hong Kong na lang naman siguro nasa 350 to 400 Filipinos. And most of them are in the household work or household chores. Di ba? In Europe, siguro sabihin mo na 100 to 200,000. And most of them likewise are in the household chores or household work. In Middle East, medyo half-half. Pero nasa 500 din, 500,000. And most of them are household chores and household work. Pero may mga professional din. Like nurses, engineers, kasi talamak ang construction dun eh. Physical therapists, occupational, and so on and so forth. Doctors, pati doctors meron din. Okay? So, how will you be able with these articles, how will you be able to protect them? How will you be able to promote and protect their work and welfare? Kaya meron po tayong Migrant Workers Act of 1995. In fact, these articles are prelude to the institutionalization of migrant workers. And by instituting migrant workers, we have now the promulgation and passing of law to formalize the protection and promotion of their welfare. Okay? So we have now Republic Act 8042 or the Migrant Workers Act of 1995 as amended by Republic Act 122 rationalizing Migrant Workers Act of 1995. Okay? Mabilis ba? Hindi naman. Okay lang. Gusto niya rin umuwi eh, di ba? Okay. So, ayun. Dito muna tayo. Sa Republic Act 122. Anyway, Republic Act 122 is the new law that supersede Republic Act 8042. So, we will substantially discuss 122. Although, there are some provisions in Republic Act 8042 which are still enforced. Mamaya, you will see it when we discuss already the cases. Okay, so prior to Republic Act 122 or 8042, we have already Article 13 of the Labor Code of the Philippines up to Article 40, Article 39. These are the laws on overseas employment. But because of Republic Act 8042 and Republic Act 122, okay, most of the laws provided under Article 13 to Article 39 of the Labor Code of the Philippines as amended are now superseded by the provisions under Republic Act 122. Okay? So we go back to Article 13. What is recruitment and placement? Okay. Ito, hindi ko binabasa to. Baka kala niyo binabasa ko. Wala akong binabasa. It so happened na long weekend, kaya sabi ko, I decided to conduct online para at least mahaba-haba naman yung ano ko sa probinsya. Okay? Wala kasi akong Masonic activity, that's why I'm here. Na-cancel na. And fortunately, I am now a past president of our Mason, kaya okay na. Marami na akong time, diba? Pero balik sa April, balik ulit sa Grand Line naman, sa Grand Lodge of the Philippines. Hindi na sa local, parang hindi na mayor, doon na sa taas naman. And hopefully, sana, di ba, panalangin nyo naman, lumabas na yung appointment. Ang dami nang lumalabas, wala pa rin kami. Buti pa yung mga dilawan at saka pinklawan, nag-enjoy na sila. At nandun pa rin sila, naka-retain, di ba? It's still almost 3,000 positions in the government, still held by Duterte appointees. Yeah. Siya nagsa-sour grape, dapat lang kasi nag-ano naman ako nagkampanya naman kay BBM yung mga hindi nangampanya, sila yung nandyan. I don't know bakit si BBM napakabagal. Anyway, sige. Going back. Okay. Illegal recruitment and placement. Any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, procuring workers includes referrals, contract services, promotion, or advertisement for a fee. Okay? Either for employment for abroad or local. Okay? With or without consideration, provided that the recruitment and placement of 2 or more persons shall be deemed as such a recruitment and placement. Okay, by this definition alone of recruitment and placement, okay, if it's undertaken by a non-licensee or non-holder of authority, it becomes illegal, di ba? Okay. If the licensee or holder of authority is armed with their authority to recruit and place workers like a private recruitment entity. Alam niyo po ba yung private recruitment entity? The private recruitment entity is an entity given with an authority to recruit and place workers for abroad. In their capacity, they deploy workers and they facilitate the hiring and eventually deployment of workers for free. Meaning, hindi muna sila maniningil. But eventually, when they got deployed, a parcel and portion of their salary will be deducted, provided that's fair and reasonable. Okay, and that will serve as payment for the facilitation of their employment and deployment abroad. Yan yung private recruitment entity. When they conduct something which is contrary to their purpose for their establishment. When you say contrary, kunwari, sila, okay, deploy now and then you will charge later. Pag ginawa nila, nagpabayad na sila. Right then and there. Meaning, applicant, meron kayong mga konting singilin sa mga medical, etc. and so on and so forth. That is already illegal recruitment. Okay? If it's done by private recruitment entity and they charge already fees for their processing, for their application, that is tantamount to illegal recruitment because that is not in accordance with the purpose for which they are established. Okay? On the other hand, private fee charging employment agency. These are the agency which was granted or afforded license by the Department of Migrant Workers. License. So, in a nutshell, these are the agency who will charge a fair and reasonable fee at the outset from application up to deployment. Kumbaga, nagcha-charge na sila. Medical, processing, so on and so forth. Okay? But, they cease to charge you already when you got deployed. So, wala nang singil. Kasi, nagbayad na kayo eh. Until you will be deployed. So, if they're now, gagawin nila, ganito. Cha-charge kayo. Now. And then, it continued until you were deployed. May mga ganong nangyayari. Okay? You will continue deploying. And continue charging those deployed workers. Then, they are considered illegal. Again, illegal. Okay? You follow? Okay. Let's say, for example, you are a corporation. Or, specifically, you are a travel agent. Or a managing partner of a travel agency. And at the same time, you engage in the business of recruitment and placement. That is also illegal. Okay? Okay. When you said, kanina I made mention of an act that constitutive of recruitment and placement. What are these acts? Canvassing, enlisting, contracting, transporting, utilizing, hiring, procuring workers, referrals, contract services, promotion, or advertisement. If you did any of these things and you have no license or authority to do all these things, then you are also illegal. Okay? Sabi ko kanina, when you ask workers to apply for you and then you deploy them abroad. However, your authority is only local employment or manpower within the Philippines. But you deploy workers abroad. That is also illegal recruitment. Okay, follow? Parang nag-stop. Are you still there? Parang nag-stuck eh. I don't know. Has something to do with the internet siguro. Okay? So, you still heard what I said a while ago?
Pwede pa ulit, sir.
Okay. As I've said, manpower agency kayo for local only, but you include the deployment of workers for abroad, which is contrary to your purpose for which you are established as a manpower or local manning agency. That is also illegal recruitment. When you hire workers, when you hire employees, okay, who who will, let's say, recruit or place workers beyond to your jurisdiction, that is also illegal. Mamaya, I will discuss all those prohibited activities. Now, we're still on discussing yung definition of recruitment and placement. What makes it illegal is when you contradicts all the acts which may constitutive of recruitment and placement, or when you conduct purposes contrary to what you have been established as a placement or recruitment agency. Okay? Agree? So when you're undertaken, even if you conduct all these acts constitutive of recruitment and placement, you canvass, enlist, contract, utilize, hire, procure, you refer employees, you come up with the contract services, you promote and advertise, okay? But you have no license or authority to do that, then it is also illegal. Okay? Understood? So let's go to the prohibited activities. What are the prohibited activities? Even though it is conducted by a licensee or holder of authority, but you conduct it unnecessarily, or you exercise severity in the conduct of your business, then it is also illegal. So example, one is when you charge an excessive fees or charges against the workers to be deployed more than the schedule of allowable fees that provided for you by the Department of Migrant Workers. Kasi merong fee yan eh. Fee ng recruitment, fee ng medical, fee ng lahat ng mga processing fee, etc. There should be a ceiling, there should be a schedule of allowable fees. If you exceeded that, then that is also considered illegal recruitment. Okay? When you publish or make a false notice information relating to the recruitment and placement of workers. Example, parang kunwari sabihin nyo, available lang placement sa Ukraine. Ngayon, wala naman doon placement ngayon because there is war there, di ba? In fact, there is a ban on the recruitment and placement of workers there. So that is a false notice. You publish either in a newspaper of general circulation or in broadcast, okay, or in YouTube or in Facebook, kung saan man, okay, using social media. That is also tantamount to illegal recruitment. Okay? Or you give any false notice or information, or you commit any acts of misrepresentation relating to recruitment and placement. Example, okay? You are granted only by the foreign employer job, factory worker, kunwari to Taiwan. Binigyan ka ng 100 capacity. Nag-recruit ka naman ng 300. Okay? Prinamisan mo sila lahat ng factory worker. Pero ang allocation mo lang is 100. Okay? So, pwede bang magreklamo yung 200 na pinangakuan mo? Siyempre. Because you give them false hope or notice, or you misrepresent dahil 100 lang ang location nyo. Kasi every time that you recruit and you deploy, binabawas mo yan. Sa agency, if you have gone to a placement agency, you can see the bulletin boards or the tally there kung ilan pa yung kailangan. At pag nilagay mo doon, sobra sa dapat, that is misrepresentation already. And that is tantamount to illegal recruitment. Okay? Ano ba? When you deploy workers to job abroad which are harmful to their health or violates the dignity of a person as a human being, that is also tantamount to illegal recruitment. Example, military operation. You hire a mercenary. Siyempre, malaki ang ano niya. Malaki ang sweldo niya pag mercenary ka sa abroad, di ba? Okay? But you expose your deployed workers there to threaten in their respective lives and live, di ba? So, that is also dangerous. Or you expose them to a toxic waste or substance pero wala silang proper training or seminar to that exposure. So that is also tantamount to illegal recruitment. Okay? You influence your subsidiary or your partner agency not to employ workers who has not applied to your agency as a requirement. Parang, halimbawa, nag-apply sa'yo, so hindi mo tinanggap kasi kulang na, sobra na yung na-deploy mo. Kumbaga, he ran out of employment opportunities in your office. Pero dahil masama kang tao, gagawin mo. Okay? Kahit mag-apply siya doon sa, it so happen na sister company mo, huwag niyong tanggapin yan. Hintayin para bumalik siya sa akin at hintayin na lang na magkaroon sa amin. Di ba? That is also illegal recruitment. Okay? Worse is that when you induce a worker, kunwari, natanggap na siya sa agency A, then, sabi mo, sige, dito ka sa amin. Kasi walang kwenta dyan sa agency A na yan. Dito ka, mas malaki yung sweldo. Okay? Or, hindi pala, mas pogi kami kasi dyan sa agency na yan. Okay? Well, unless you induce him to go to your agency because to save him or to liberate him from any abuses, that's fine. Walang problema. Pero when you compete, okay, unfairly with the other agency just to get this person at the expense of your competing agency, then that is illegal recruitment also. Okay? When you fail to file the report on the listing of those deployed workers to the Department of Labor. Pero ngayon, hindi na Department of Labor, Bureau of Migrant Workers na. So, when you fail to report the list of those deployed, list of those applicants, list of underpasses, and so on and so forth, dapat nire-report yan eh. Every development of the agency. Failing to do that, that is also tantamount to illegal recruitment. Okay? Like what I told you a while ago, when you interlock directors or officers and employees of the business in travel agency, at the same time recruitment and placement agency. Bawal po yun. It should have a separate and distinct personality with the travel agency. You have nothing to do with the travel agency. Because if you interlock directors, officers of that agency, whether it's a travel and recruitment or placement agency, that is also illegal or constitutive of illegal recruitment. Okay? When you deny the authority to be deployed or deny any travel to your applicant for deployment, kahit qualified na siya, solely on the purpose of financial or monetary consideration, kasi hindi pa siya nagbayad, mayroon siya pang kakulangan. Okay? Siyempre, it depends kung substantial yung kakulangan. Let's say, kunwari, ang processing fees nasa 50,000, 1,000 lang yung binayad, wag naman. Pero kung 49,000 na ang binayad, 1,000 na lang, only for that purpose, you don't deploy, ibang usapan nyo. Okay? That is also illegal recruitment. When you withhold documents for travel, like ito, nangyayari to, yung mga passport, ayaw nyo ibagay yung passport kasi meron pang mga hindi nabayaran sa inyo. Well, if it's a substantial amount, siguro naman you can justify it. Pero pagka minimal na lang, bigay nyo na. Okay? Anyway, even in overseas employment, in case of doubt, the case shall be resolved still in favor of the worker. Wala tayong magagawa dyan. Still in favor of the worker. Okay? Okay. In case of failure to deploy the worker for abroad, for justifiable reason, hindi for unjustifiable reason. And since you fail to deploy, dapat i-reimburse mo siya, di ba? Yung mga expenses, less yung mga reasonable and fair expenses that you incur. Wag naman yung walang full refund. Let's say 50,000 yung processing, lahat-lahat na. Tapos i-refund mo lang siya. Kunwari 1,000 out of 50,000. Hindi na tama. Siguro 1/3 of that kukunin mo, 2/3 will go back to the applicant worker, okay lang. Or 1/4, then 3/4 will go back to the applicant worker, okay lang. Huwag naman yung half-half or kaya more than that. Okay? Okay. There are also prohibited activities where when you engage in recruitment and placement and you enter into a memorandum of agreement with a financing company. Okay? Tapos, syempre, walang pambayad yung applicant. I-refer nyo ngayon sa financing. Okay? If it's voluntary on the applicant, that's fine. Walang problema. However, if you direct or require him na, dito ka lang sa financing company na to, kung hindi, i-deny ko yung travel mo. I-deny ko yung deployment mo. Hindi pwede yun. Okay? Dapat voluntary lang. Okay? Or, when the financing company charge him or her more than 8% per annum interest, let's say 9 or 10%, that is also not allowed. And if you tolerate as a private recruitment agency or private recruitment entity or private fee charging employment agency, you also become illegal. Okay? When you require the worker to conduct his medical examination only to the clinic or hospital exclusively and solely, since you are in collaboration with them or you are in memorandum of agreement with them, that is also not allowed. Or where you require the worker to enroll in a training institution where you had forged your MOA with them, and that is solely and exclusive, walang voluntariness on the part of the worker, that is also illegal recruitment. Okay? When you allow a foreigner to manage the recruitment and placement agency, sa Pilipinas, nangyayari din yan. Okay? Kasi ang investor, foreigner, majority investor, you should not allow it. Only Filipino citizen can manage a recruitment and placement agency. Okay? Klaro? Recto. Okay. Ano ba nga? Sa may ground pa rin tayo. Well, what I discussed you are all in sections 5, 6, 7 of the Republic Act number 122. Okay? Okay. When you say illegal recruitment, there are two kinds of illegal recruitment. One is simple illegal recruitment and qualified illegal recruitment. Qualified illegal recruitment are subdivided into two more. We have the illegal recruitment by a syndicate and illegal recruitment in a large scale. Okay? So, simple illegal recruitment, when you recruit and place workers, not more than 2. So, 2 or less. So, that's simple illegal recruitment. When you recruit and place workers, 3 or more workers, that is qualified illegal recruitment in a large in a large scale. When there is a confederation, conspiracy, collaboration of 3 or more persons in a recruitment entity or agency, that is a qualified illegal recruitment by a syndicate. Okay? So again, simple illegal recruitment, then qualified illegal recruitment. Under qualified illegal recruitment, there is an illegal recruitment by a syndicate and illegal recruitment in a large scale. Illegal recruitment by a syndicate is there is a collaboration, confederation, cooperation of 3 or more directors, officers of the agency to recruit and place workers for deployment abroad, undertaken by a non-licensee or holder of authority, or a licensee or holder of authority who commits any of the prohibited activities as I've mentioned a while ago. Okay? On the other hand, illegal recruitment in a large scale, when you recruit and place workers 3 or more in number, and you undertake it as a non-licensee or holder of authority, or a licensee or holder of authority but commits any of the prohibited acts as I mentioned, then that is illegal recruitment in a large scale. Okay. Penalty for simple illegal recruitment. Penalty. I think that is 1 million to 2 million pesos fine. Okay. 12 years in 1 day. Imprisonment up to 20 years in 1 day. Malaki-laki, no? Taas pa rin. Okay. Illegal recruitment committed by a licensee or holder of authority. Ibig sabihin, legit sila. Legit na private recruitment entity or private fee charging employment agency. Legit. But, commit any of the act which I mentioned kanina, yung sinabi ko na ginawa. The penalty there is 500,000 fine to 1 million pesos. And an imprisonment of 6 years in 1 day to 12 years. Okay. Okay, doon naman tayo sa qualified. Qualified illegal recruitment. Qualified. The either illegal recruitment in a large scale or illegal recruitment by a syndicate. The penalty is 2 million fine up to 5 million. And an imprisonment of what? Life. Life imprisonment. Or life. No bail nga actually ito. In fact, just to share you something, I have a case already. Tatlo. Illegal recruitment by a syndicate, illegal recruitment in a large scale, and simple ba? Dinalawa ko, no? Okay lang yan. Pero I'm sure that they will get their acquittal kasi mahina yung case. By the way, sa accused pala ako, sa accused. Kasi pag sa complainant ka, wala. Maliit lang yung acceptance fee. Pagka doon sa employer side ka, syempre yun ang mga pera. Doon yung malaki yung acceptance. But syempre, hindi ko naman i-handle to kung I cannot see any future of the case. I saw future. Kaya madi-dismiss yan. Ma-acquit sila for sure. Now, in illegal recruitment, can the recruitment and placement agency, including its officers, directors, or key officials and employees of the company, be liable criminally, civilly, and administratively? Yes. Okay? On the criminal level, there is imprisonment, there is fine. On the civil level, there is payment of damages, diba? Actual, moral, exemplary damages, including attorney's fees in the concept of damages. 9:06 pero sige, bilisan ko lang. On the civil aspect naman, revocation of the license or authority. Okay? Okay, so other provisions of Republic Act 122 will be discussed together with the cases. Let's go first with the cases. Ano ba to? You go over with Antonio Serrano versus Galant Maritime and Telemaris Ships Management and Intermare Maritime Agencies. Okay? In this case, okay, this applies to Section 7 of fifth paragraph of Republic Act 122. Also, Section 10, fifth paragraph of Republic Act 8042. What is this all about? Okay. In this case, in case of, this is the provision of the law. In case of dismissal of an overseas Filipino contract worker without just valid or authorized causes for termination. Okay? The employee unjustly, unfairly, unauthorizedly, invalidly dismissed from service shall be entitled to full reimbursement of all the expenses he incurred in recruitment and placement. Plus, ito yon. Plus, okay, the unexpired duration of the employment. Or, okay, or, ito yun. Ito yung importante sa lahat. Or, not more than 3 months. Whichever is less. Okay? You get the gist of the law. So, ibig sabihin nun, pag unjustly dismissed ka, unauthorizedly dismissed, invalidly dismissed ng agency mo, ng principal employer mo, okay, you will get full reimbursement plus okay, an expired portion of the contract, or ito yung dapat mawala, or not exceeding 3 months, whichever is less. Okay, the case of why we have to discuss the Serrano and Tenamaris case, Yap versus Tenamaris case, because this provision that I discussed was rendered unconstitutional in these two cases. Okay. Bakit? Bakit unconstitutional? What is the effect if you render it unconstitutional? It means, ladies and gentlemen, that yung provision na to, nakalagay kasi doon, di ba, may limitation, may statute of limitation na hindi ka makaka-recover ng back wages mo on the entire unexpired portion if you still have 6 months. Kasi hanggang 3 months lang ang kaya. Kuha nyo? You get it? You follow, guys? So meaning, even if it's 6 months or more, yung unexpired portion mo, the only amount that you can get is equivalent only to 3 months. Ngayon, sabi ng case na to, yung dalawa, okay, it was rendered unconstitutional. So in short, what does it mean? It means that you can still recover the inexpired portion. Kunwari, okay, like in this case, dalawa pareho. Na-terminate ka unjustly. You have a 2-year contract with the principal employer. Deployed ka ng agency mo. Okay, you have a 2-year contract. After 3 months, okay, you were unjustly dismissed ng employer. So, 3 months, meron ka pa 18, di ba? Tama? Ay, hindi. 24. 3 months. May 22 ka pa. Kasi 2 years, 24 months eh. May 20, mahina kasi tayo sa math eh. So, 24 minus 3, 21. 21 months. Di ba? Tama? So, since it rendered unconstitutional, itong batas na to na 3-month limitation, wala. You can still recover the 21 months. Okay? That is the point in this case, because that's why it was rendered unconstitutional. Okay, you get it? Follow? Okay ba? Okay. So, let's go to Prime Star International Promotion versus Norly Baybayan. This is a new one. New bagong case po ito. Yung kay Prime Star. Okay. It's a 2020 case. This is on the substitution and alteration of employment contract. Okay. Okay. This is the case of si Norly Baybayan. Jumble na yun. Ano ba? Yung inaral ko. Hinay siya ng Prime Star at dineploy siya sa parang wakul yung ano to, yung mga sa luxury ba? For 24 months contract sa Taiwan to. Okay? Ang salary niya doon parang lumalabas, kung di ako nagkakamali, nasa 15,000 NT. Ano ba yung NT? Taiwan yun eh. Taiwan currency. Equivalent yata nun is 1:1.5 sa atin. Tama ba? Parang gano'n. So, 15,000 NT. Kaya lang, nung nandun na siya, siguro, tuso yung agency niya. Ginawa na lang 9,000. Natapos naman yung kontrata niya, 2 years. Tapos yung kontrata niya for 24 months. Nung bumalik siya dito, siyempre, siguro, kumuha siya ng advice sa mga attorney. Hindi ako yun. Mga lawyer na gustong kumita. Okay? So, in-advisean siya, mag-file ka ng case kasi inagrabyado ka ng employer mo. Okay? Sinubstitute yung contract mo. Di ba? Bawal yun. Which is tama naman, bawal. Okay? And then, apart from that, nag-ano siya ng full reimbursement doon sa transportation niya. Kasi, yung travel niya medyo malayo eh. Going to the office. Nirelocate siya doon sa place, pero may trouble pa siya. Na siguro it cost him a lot also for the transportation and even meal. So, pina-reimburse na ngayon yun. Initially, sa labor arbiter, okay, dinismiss yung kaso. Okay. So, nag-apila ngayon sa NLRC. Nung nag-apila, ni-reverse ng NLRC. So, ang ginawa ng NLRC, in-award yung reimbursement ng transportation expense niya. Meron naman siyang resibo eh. Apart from that, yung difference pa, yung salary differential ng 9,000 to 15,000. Okay? Totaling around nasa 184,000 to 190,000 NT yung kanyang award. Okay? So, nag-MR, denied. Okay, doon na tayo sa Supreme Court decision. The Supreme Court said that when an employment POEA standard employment contract was already approved, kasi normally ang binibigay sa worker is a pre-approved standard employment contract, and this is already approved by the POEA before wala pang Department of Migrant Workers. The same has the force and effect of law between the parties, between the agency and the overseas contract worker. So, since it is approved, you cannot substitute it, especially when it is already in effect. Ang ginawa kasi ng agency niya, nung nandun na, na-deploy na, yung kontrata niya biglang binago from 15,000 to 9,000. So that's tantamount to deceit or dishonesty. So it cannot be. Di pwede. So you have to respect even though yung kanilang agreement is more than enough. More than enough dun sa minimum standard na siniset ng kontrata nila. Kung halimbawa, 9,000 still okay naman yon. Parang minimum wage naman yan, okay lang. Pero, you have to respect what has been approved at the initial stage. Otherwise, everybody can commit dishonesty during the effectivity of the contract. So, yun ang sabi ni Supreme Court, which is tama. Okay? The case of, saan na tayo? Yun. Jolly Chodoro versus Tikay Shipping. Jolly Chodoro naman. Ito naman yung CBA prevails over POEA Standard Employment Contract. Okay. Si ano naman to? Jolly Teodoro versus Tikay Shipping. Okay? Si Jolly Chodoro was hired as a chief cook. Chief cook ng isang cruise line. Okay? Saan ba to? Saan ba yung cruise line na to? Sa parang sa ano? KSA, Kingdom of Saudi Arabia. Ano gano'n? Okay. Hindi ko na masyadong matandaan. Nagka-jumble-jumble na yung ano, binasa ko eh. Basta chief cook siya, hired siya ng Tikay Shipping. Okay? Although deployed siya with MB Cruise Line. Okay? For 8 months. 8 months lang. 8 months. So, meron silang, kasi pagka mga ganyan, yung mga cruise line, meron normally union yan. Yung, I don't know if you're familiar, yung Amusuk, parang gano'n. Meron sila talagang union dito sa Pilipinas. And they insinuate that they are member automatically with the union in the Philippines. And since the Philippines has union, meron talaga silang infused na collective bargaining agreement. And this collective bargaining agreement was instituted together with the POA Standard Employment Contract. Binibigay ito as part and parcel of the agreement with the agency. Although itong CBA, hindi na ito nakakarating sa principal employer. Okay? Ganun ang kalakaran dyan. Okay. In the contract, si Jolly Chodoro, tinanggap pa rin siya despite of the fact that he revealed that he is suffering from diabetes mellitus. May diabetes siya. Okay? Pero tinanggap pa rin kasi magaling na cook eh. Tinanggap pa rin siya. Winave yung sickness niya na gano'n. After 3 months yata of exposure with the cruise line, na-assign siya doon sa place wherein na-aggravate yung kanyang diabetes. So, he turned him to be initially, nabulag siya sa left eye. Okay? And then, eventually, buo na. Pero, binalik muna siya sa Pilipinas bago, nung nabulag yung left eye niya, binalik siya sa Pilipinas to have another examination. But while conducting the examination, nabulag siyang tuluyan. The findings was that, sabi naman, hindi yan work-related, sabi nung hospital dito sa Pilipinas. But, since his exposure to the environment in cruise line, okay, incidental to that exposure, kaya siya nabulag. Pero hindi yan work-related. Okay? So, in short, hindi na siya pinabalik. So, nag-file siya ngayon ng case for money claims with the agency. Okay? So, sabi ng agency, we should abide by the POA Standard Employment Contract that kasi sa Standard Employment Contract, nakalagay kasi doon na if you contract illness or sickness, whether it's related or not related to your work, you are automatically be repatriated and you lost your right to claim more benefits. Parang no work, no pay ito. Okay? Doon sa POA Standard Employment Contract. However, doon sa CBA niya, nakalagay na you should be fully compensated in accordance with your whole contract, which is 8 months. Okay? Regardless of whether or not the contracted illness which capacitated you from furthering your work or for continuing your work, okay, is related or not related to your work. Okay? Agree? Understood? So, which will prevail? Is it the POA Standard Employment Contract or the CBA? Kasi sabi naman nung principal employer, hindi naman namin alam yan eh. We don't know anything about the CBA. We don't honor that. Okay, yes, you don't honor that. Exactly. Because we don't have jurisdiction over you. Doon sa principal doon sa cruise line. However, ito yon, we have jurisdiction over the employment agency. So, since the employment agency is solidarily liable, okay, with the principal employer, and we cannot go against the principal, so we will go against the employment agency. Okay? CBA will still prevail because CBA has more benefits, has more privileges than POEA Standard Employment Contract. Again, we go back to the law. In case of doubt, it shall be resolved in favor of labor, di ba? Article 4 of the Labor Code of the Philippines as amended. Okay, lapit na. Romero versus People. Illegal recruitment. Dito, kaya Romero versus People, isa lang dito ang nag-recruit. Isa lang ang ni-recruit din. Si Romero, ang ni-recruit niya isa lang. Kaya sabi niya, walang illegal recruitment dito kasi the law is clear. Diba? Illegal recruitment is only, you become liable only when you recruit and place workers at least 2 or more in number. Nakalagay sa Article 13 yan. Nakalagay sa Section 5 yan. Diba? Pero sabi ng Supreme Court, the mere fact that you commit any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, procuring, includes referral, contract services, promotion, or advertisement for a fee, for abroad, with or without consideration, even to one person, that is already illegal recruitment. The intention is clear already. Okay? So the law, the rationale of the law is not to limit recruitment to 2 or more. The fact that you recruit even one, the intention was already fulfilled, was already established. Because you commit any of the acts that I have mentioned. And you are not a licensee or holder of authority. Yun ang sabi ng Supreme Court. Amen. Okay, let's go to last. Last na. Jolly Quaresma versus Ay, hindi. Jasmine G. Quaresma versus White Falcon Services and so on and so forth. Actually, tatlo yung involved dito eh. White Falcon, ano pa ba yung involved dito?
Beckman po ata.
Ano na?
Beckman.
Beckman. Yan, Beckman. May isa pa. May isa pa. Kalimutan ko na. Ano ba yan? Albert Hospital. Yan, yun. At saka, yung nasa Saudi Arabia. At saka yung, basta tatlong liable dito. Including their officers, directors, and employees. Kaya nga, this why liability of recruitment, foreign agency, and the foreign-based employer. So, there are three personalities involved here. White Falcon, Beckman, parang Beckman naman to and then Albert Hospital, and the officers and directors of the agencies and the hospital. Okay? Okay, what happened here? Si Jasmine, anak ito ni Simplicio and Mila Quaresma, ay isang nurse sa Albert Hospital sa Kingdom of Saudi Arabia. Okay? Hinire siya as nurse doon for 3 years. Yata, 3 years. Tapos, 250 na lang dollars per month. Okay? After working for some time, natagpuan na lang siya doon sa dormitory niya na patay na. Tapos, he was subjected to examination doon sa Saudi. And the examination conducted found her to be poison. Nilason. Poison. Okay? So eventually, her body was repatriated here in the Philippines. At napunta ito sa Cabanatuan City Hospital. It's a locally funded hospital in Cabanatuan. Inautopsy siya ngayon doon. Siguro, bakit siya inautopsy? Kasi nakita sa carcass niya siguro in plain view na may mga hematoma, contusions, bruises, so on in all over parts of the body. Kaya inautopsy. Cabanatuan Hospital found when the Cabanatuan conducted the autopsy, they finally found that Jasmine died of violent interventions. Like, mayroong abuses. Physical, sexual abuses. Kasi meron siyang hematoma sa vaginal canal, meron siyang bruises, meron siyang hematoma on different parts of the body, including strangulation, parang gano'n. Okay? So, siyempre, siyempre, yung patay na, hindi na makaka-complain, di ba? So, yung nanay at tatay niya, nag-file ng claims against Beckman, White Falcon, Albert Hospital, and the officers and employees therein. Okay? So, again, ang labor arbiter, dinismiss na naman yung kaso. Siguro may bayad. I don't know. May bayad, ano? Then, nag-inappeal sa NLRC. Dito sa NLRC, okay, ni-reverse at sinet aside yung decision ng labor arbiter. In fact, nag-award dito ng parang $100,000 US laki parang 5 million yun, more or less. Nag-MR, denied. Napunta sa CA. Itong CA, hindi ko alam kung bakit. Binaba yung award to 80,000 na lang dollars. So, nagkapila eventually sa Supreme Court. Okay, sabi ng Supreme Court, okay, binalik ni-reinstate yung decision ng NLRC na 100,000 pesos. Plus, may plus pa. May plus na 6% interest per annum from the finality of the decision to actual payment. Okay? And this is charged against not only to Beckman, but also to White Falcon, including the officers and employers, officers and key employees of Albert at saka pati yung mga White Falcon. Kasi ang liability is solidary. So, if you cannot go against Albert, kasi Albert, wala tayong jurisdiction doon. So, you can go against the agency here, which is Beckman. Kaya tuloy, meron tayong Beckman naman. Okay, so I think that's it.